Tonight's courtroom drama is about to take you on a ride, literally. Meet Mr. Pugh, a man accused of turning a Texas roadway into his own personal getaway track, charged with a third-degree felony, evading arrest with a vehicle. But that's just the beginning. In this hearing, we'll see him plead guilty, then immediately try to downplay a string of explosive jailhouse incidents, from arguing with correctional officers to washing clothes in a sink against orders. The judge? Not having it. We're talking blunt reality checks, probation violations stacked like poker chips, and 2 sentences that could keep him locked away for years. Watch closely, because every time Mr. Pugh opens his mouth, the tension in this courtroom spikes. And by the end, you'll be asking yourself, is this man unlucky or just unwilling to follow the rules? Let's break it down.
Mr. Pugh, in cause number 23, DCCR 1531, you're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle, and that's from June 18th of 2023. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? In that case, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? And do you fully understand them? Answer out loud, please. Thank you. The court reporter has to take everything down. And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? State tenders number 1.
No objection.
It's admitted. And Mr. Pugh, you are a U.S. citizen, correct? Is there any evidence that Mr. Pugh is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with the use of a vehicle. Sentence you in accordance with your agreement to a term of 3 years in the
Boom. 3 years in the Texas Department of Corrections. That's the cost of evading arrest with a vehicle, a charge that, under Texas law, can carry anywhere from 2 to 10 years depending on the circumstances. Here's the thing. By pleading guilty freely and voluntarily, Mr. Pugh just gave up his right to appeal. Why do defendants do this? Sometimes it's a strategic move. Taking a plea deal can mean avoiding a longer sentence if they roll the dice at trial. But it's a gamble in itself. And here, the judge makes it clear. She's locking in that deal, no turning back. Question for you. If you knew the evidence against you was solid, would you take a plea or fight it to the end?
years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Let's see. And then in cause number 19-33356, what I'm looking at right now is your jail incident reports. You don't like being told what to do out there, do you?
That's not the issue. People come to work with problems of their own.
Okay, so it's the correctional officer's faults that you don't follow the rules?
When I walked across the dorm to give a guy his bowl, I did that. I was working out in the bathroom, I did that.
Okay,
Miss Painter, she called me on my name multiple times and I asked her to identify herself. The other things that she wrote in there about me were not true. I had another officer read it to me so I know what it says.
okay. There's only one.
Mr. Washington wrote me up, and that was a lie. That's why I got moved to orange, because I actually was in blue at first. And the lieutenants don't even know why I was in there. I was actually in placement in dorm under, so to say, Stroder's advisor, but Stroder never wrote me up, so I don't even have a write-up for that.
Okay.
They don't have that in there either.
Now here's where things heat up. Mr. Pugh starts pushing back against multiple jail incident reports, accusing officers of lying or twisting events. In his version, he's being unfairly targeted. A name-calling officer, false accusations about washing clothes, even claims that the wrong uniform color landed him in a higher security pod. But here's the reality. In jail, officer reports are often given heavy weight in disciplinary hearings. Cameras can clear things up, but only if someone actually checks them. The problem? That rarely happens unless the allegations are extreme. So the question becomes, is Mr. Pugh the victim of a power trip Or is he conveniently rewriting history to save face?
Okay. I mean, it sounds like you're saying you did most of what they're saying you did
No, I
wrong
didn't do
anyway.
most of what they're saying at all. Most of those write-ups, Washington and Painter, and I think another lady, I didn't do the other things that she wrote up. Butte wrote me up for some other things, and I told her that I can't do her job for her. She wanted me to point somebody out, and that was she just wrote me up on it. So.
Okay. So Washington didn't tell you to stop talking,
No, ma'am,
and
he
you
didn't.
responded by saying, quote, "Officer, you telling me we can't talk in the bunk area? You tripping." You didn't say that?
I did not. That man did not tell me nothing that whole day. He didn't. And when I asked him if I had a write-up, he told me no. And then he actually wrote me up 2 days after they moved me from blue to orange. That wasn't even the same day.
And you didn't go to the restroom and wash your clothes in the sink, and he
No,
told
ma'am,
you
I
not
did
to do that?
I did not do none of that.
You just made all that up?
I swear, I asked the lieutenant to check the cameras and see if that's what I did, and she didn't want to do it. So that write-up was just for nothing. When I asked him if he wrote me up because they told me that I had a move card, I said, "Why am I moving from blue to orange?" He said, "I don't know." And I was like, "Well, did you write me up for something?" He said, "No, I didn't write you up. The lieutenant called and said that you had a move card, that they was placing me in my right because I have a felony case that I'm supposed to be in orange." And when I came in at first, I told them that I was supposed to be in orange, but they put me in blue and told me that they would.
Sounds like you know their job better than them, huh? You're just out there telling them what to do and where you're supposed to be and all that kind of stuff. See, here's the thing. I don't have to accept any agreements in here. And I know word out there, it's got to be getting around that I'm not accepting agreements. I'm putting people back in jail because of these incident reports. Because these people are just trying to go to work and do their job, and they don't need you or anybody else telling them how to do their job, where you're supposed to be. You're supposed to be where they tell you to be. You're supposed to wear what they tell you to wear. That's part of being in jail. You don't get to make your own rules. Stop breaking the law, and you can do what you want and wear what you want when you're out. Does that make sense?
And here it comes. The judge drops a truth bomb that slices through every excuse. You're in jail. You follow the rules. You wear what they tell you to wear. You don't make your own rules. It's not just about uniforms or bunk area chit-chat. It's about authority. In custody, refusing to follow orders isn't a minor annoyance. It's a direct challenge to the institution's control. And in a probation case like this, those rule violations can stack up as ammunition for revocation. What do you think? Was the judge too blunt, or exactly as firm as she needed to be?
It does make sense.
All right, so in cause number 19-33356, I have a motion to revoke your unadjudicated probation. This one shows that you were placed on probation December 7th of 2020 for unauthorized use of a motor vehicle. That was a 2-year probation. Looks like it was extended at least once. Is that correct?
Yes, ma'am.
Okay.
It looks like this motion judge was filed in 23, so that must be where it's told it. He's just been at large on it since.
Okay. It alleges that you violated your probation. Count 1 alleges that you committed the new offense of evading arrest, June 18th of 2023. And is that true or not true? True or not true? True. Count 2 alleges that you failed to report as directed to the probation department April 10th, May 22nd, and June 12th of 2023. And is that true or not true?
True.
Count 3 alleges that you didn't work faithfully at suitable employment and provide verification of that. And is that true or not true?
This is where the avalanche hits. One by one, the judge rattles off 8 counts of alleged probation violations, from committing a new offense, to missing check-ins, to failing to pay fees, perform community service, or attend GED classes. Mr. Pugh admits to some, denies others. But here's the kicker. Under Texas probation law, just one proven violation can be enough to revoke the whole deal. The rest? They just make the judge's decision that much easier. And when you already have a fresh felony conviction on the books, you're walking into this hearing with both feet in quicksand.
True.
I'm sorry?
Not true.
Okay. Count 4 alleges that you failed to immediately report to the probation officer a change of address and your arrest. Is that true or not true?
Not true.
Count 5 alleges that you failed to provide verification of performing the community service hours as required. Is that true or not true?
True.
Count 6 alleges that you failed to provide verification of participating in the education program for your GED. And is that true or not true? Count 7 alleges that you failed to provide verification of paying court-ordered child support. Is that true or not true?
Not true.
Count 8 alleges that you're behind in your court-assessed fees as of June 26, 2023, in the amount of $2,361. And is that true or not true?
That's true.
So he was at large since 2023? Is that what this, I would assume from this? Since there's,
That's what I would assume, Judge, just from the file stamps and the fact that his last admin was in 23 as well.
so did you just stop going to probation back in 23?
Yes, ma'am.
That's after he got arrested on the new case, apparently. That's what it appears, Judge.
No, that was before I got arrested.
Yeah, the new case is from March of 2024, so you had already stopped going for
Yes,
almost a
ma'am.
year.
Because she was planning to violate me for
This
any
is-
reason, I don't know why.
It says June 18th or 23, I thought.
I'm sorry, I'm looking at the wrong thing. Hold on. Looking at the wrong thing.
He was supposed to be.
2023, June 18th, yeah. Stopped reporting in April. New offense in June.
And just like that, sentence number 2 drops. 1 year in state jail for unauthorized use of a motor vehicle. In plain terms, that's taking or operating a car without permission, a charge that sits in a sweet spot between theft and joyriding. But here's what's interesting. The judge has now stacked 2 separate sentences back to back, which means more time behind bars, even with credit for time served. For anyone thinking probation is a free pass, this is proof that if you push too far, the state will take that second chance and slam the door shut.
I don't know if I like it or not. Guess it really doesn't matter a whole lot just because it's gonna, I already gave them the 3 on the other one.
We can rediscuss it, Judge, and raise the time.
I'll do it. All right, so I'm going to find that you entered your pleas of true to counts 1, 2, well, let me go through this first. I have also in this case, on the motion to revoke case, some documents here on the computer that have your signature on them. Did you also go over these with Mr. Parker?
Yes, ma'am.
And you fully understand them?
Yes, ma'am.
Again, you understand if I follow this agreement that you'll be waiving or giving up any right to appeal.
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. All right, I'm going to find that you entered your pleas of true to counts 1, 2, 5, 6, and 8 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of unauthorized use of a motor vehicle. Sentence you in accordance with your agreement to a term of 1 year in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certifications in each of these cases that shows these were agreements that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker.
So here's where we land. Mr. Pugh walks out of this hearing with 2 convictions, 2 sentences, and 0 chance to appeal. The lesson? When you're already on thin ice with probation, every rule matters. Skipping check-ins, ignoring orders, getting into disputes with officers. It all adds up. And when the evidence is stacked, even a strong personality in the courtroom won't change the outcome. What do you think? Was this justice served, or was the system too quick to throw the book at him? Drop your thoughts below. And if you found this breakdown as gripping as we did, hit that like button. Share this with a friend who loves true courtroom drama. And don't forget to subscribe for more jaw-dropping legal showdowns right here on Court Scene TV.